On the morning of January 28, 2026, a convoy of FBI vehicles pulled into the parking lot of the Fulton County, Georgia election office in Union City. Federal agents had a warrant signed by Magistrate Judge Catherine Salinas. The warrant was specific: all physical ballots, all ballot images, all tabulator tapes, and all voter rolls from the 2020 presidential election. Every piece of paper that had been used to count the votes in the most contested presidential election in modern American history. And standing inside one of the FBI evidence trucks, as agents loaded that material, watching, observing, running a parallel investigation of her own, was Tulsi Gabbard, the Director of National Intelligence of the United States. This is the story of what happened that morning, how it got to that point, and what the seizure of those ballots means for the legal and political future of a country still divided over what happened in November of 2020. To understand why the FBI was in Fulton County that morning, you need to understand a sequence of events that began 6 years earlier and never fully resolved. Donald Trump lost Georgia in 2020 by 11,779 votes. It was the first time a Republican presidential candidate had lost the state since 1992. Trump and his allies immediately alleged fraud. They alleged that Fulton County, which encompasses Atlanta and represents the largest single vote pool in the state, had counted ballots illegally, had introduced fraudulent absentee ballots into the count, and had manipulated tabulation equipment to flip results. Georgia state officials, including Republican Secretary of State Brad Raffensperger, investigated those claims and found no evidence to support them. Multiple audits, including a full hand recount of all 5 million ballots cast in Georgia, confirmed the result. Trump lost, but the legal and political battle never ended. In 2023, Fulton County District Attorney Fani Willis indicted Donald Trump and 18 co-defendants on charges of racketeering and conspiracy related to their efforts to overturn the Georgia election result. That case stalled, then collapsed under the weight of procedural challenges and the political transformation that came with Trump's return to the White House in January 2025. One of the first acts of the new Trump Justice Department was to pursue federal legal remedies against officials who had, in the administration's framing, weaponized state law against the president. That pursuit eventually produced the warrant that sent FBI agents into Fulton County on January 28th. The Department of Justice had filed suit against Fulton County in December 2025, seeking access to the 2020 election materials. The suit argued that federal law required states and counties to preserve election records for 22 months after an election, and that Fulton County's long-term storage of those materials created an ongoing federal access right. County officials disputed that interpretation. The litigation moved quickly, and in late January, a federal magistrate judge agreed with the DOJ's position and signed the search warrant. What made the raid extraordinary was not the warrant itself. It was who showed up to watch it executed. Tulsi Gabbard has no domestic law enforcement authority. The Director of National Intelligence oversees the intelligence community, the CIA, the NSA, the Defense Intelligence Agency, and 14 other agencies. She does not investigate election fraud. She does not have a role in FBI search warrant execution. She does not work for the Justice Department. And yet, according to multiple witness accounts and her own subsequent public statements, Gabbard was present at the Fulton County election office that morning, was inside one of the FBI evidence trucks, and was conducting what she described as a parallel investigation under her own authority. That presence generated an immediate firestorm. Senate Intelligence Committee Vice Chairman Mark Warner demanded answers. Former federal prosecutors publicly stated that a director of national intelligence observing a domestic law enforcement operation was an extraordinary departure from established norms. Legal scholars raised concerns about the use of intelligence community resources in what appeared to be a domestic political investigation. The constitutional questions multiplied. Gabbard testified about the raid before the Senate Intelligence Committee on March 18, 2026. She confirmed that President Trump had personally asked her to observe the operation. She denied physically handling any ballots. She acknowledged she had been inside an evidence truck, but described it as empty at the time she entered. She denied that her presence represented any intelligence community involvement in domestic law enforcement. Committee members were not satisfied. Warner noted that the distinction between observing an operation and participating in one becomes legally meaningless when the observer is the Director of National Intelligence, a position that carries enormous institutional authority over the agencies that produce intelligence about American citizens. The ballots themselves are now in federal custody. Rob Pitts, the chair of the Fulton County Board of Commissioners, issued a statement after the raid saying that the 2020 election ballots had been secure in the facility and that he could no longer assure the citizens of Atlanta or the world that those ballots were still secure. That statement carries weight beyond its immediate context. The integrity of election records depends not only on their physical preservation, but on the chain of custody that surrounds them. When federal agents remove election materials under a warrant, the legal framework for handling those materials becomes critical. If ballots are damaged, altered, or improperly stored during the federal custody period, the evidentiary value of any subsequent analysis is compromised. If the analysis produces findings that support claims of fraud, those findings will face immediate legal challenge based on the chain of custody. If the analysis produces no evidence of fraud, the administration will face the question of what the operation was actually for. The warrant itself does not specify what investigators expect to find. Warrants rarely do. They establish probable cause, a legal basis for believing that the materials sought contain evidence of a crime. The DOJ's warrant application argued that a review of the physical ballots and tabulation records was necessary to determine whether any federal laws had been violated in the conduct of the 2020 election. That is a legally sufficient basis for a warrant. It is also, to critics of the operation, an extraordinarily broad mandate applied to materials that have already been audited multiple times by state officials who found nothing. What is the federal government looking for that 5 independent state audits missed? That question does not have a public answer. What it has is a political context. Donald Trump has repeatedly claimed, without evidentiary support that has survived legal scrutiny, that the 2020 election was stolen. He has made that claim the central organizing principle of his political identity for 6 years. The seizure of the Fulton County ballots is the most aggressive federal action yet taken in support of investigating those claims. Whether it produces evidence or not, it produces a narrative. And in the current media environment, the narrative of federal investigators going through election ballots box by box is politically powerful regardless of what those investigators find. The families and communities whose votes are contained in those boxes face a different kind of uncertainty. Every ballot seized is the physical record of a citizen's participation in democracy. The handling of those records by federal agents under a politically charged warrant is experienced differently depending on where you stand politically, where you live, and what you believe happened in 2020. For Trump supporters, this is accountability. For critics of the administration, it is the use of federal law enforcement to validate a conspiracy theory that courts have repeatedly rejected. The legal proceedings surrounding the raid are ongoing. Fulton County officials have filed a motion challenging the scope of the warrant. Civil liberties organizations have filed amicus briefs arguing that the seizure of election records implicates First and Fourth Amendment concerns that the magistrate's warrant failed to adequately address. The DOJ has not publicly disclosed a timeline for completing its review of the seized materials. Gabbard's involvement has prompted calls from several senators for a special counsel to investigate whether the intelligence community's involvement in a domestic election investigation violated the National Security Act. Those calls have not produced action. What the Fulton County raid has produced, with certainty, is a legal and constitutional confrontation that will not resolve quickly. The ballots are in federal custody. The Director of National Intelligence was in the evidence truck. The President of the United States asked her to be there. And 6 years after an election that more than 70 courts found to be valid, federal agents are going through the physical ballots one more time. The investigation continues. This is Federal Watch Network.